Happy November. Welcome all of you joining today's class. Favor at home and learn. Understanding the prelim title 2020 for agents, buyers, and sellers. I'm Pauline Lam from Kota Realty, your 2020 co-chair education committee for San Gabriel Valley Realtors. A few housekeeping tips. All participants will be muted. Should you have any questions, please enter it into the chat box. The speaker will answer it during the Q&A session. This meeting is being recorded and will be available on our YouTube channel by San Gabriel Valley Realtors. Now, I'm so happy to introduce you, our committee member, beautiful Miss Sylvia Rosage, to introduce our speaker today, Joe Haggerty. Thank you, Sylvia.
Thank you. Good morning, everyone, and I hope that you enjoy this stay at home, safer at home event brought to you from our West San Gabriel Valley Realtors. Today we have Joseph Haggerty from Orange Coast Title to give you some feedback on what he does best. And it so happens today is his birthday, so happy birthday, Joe.
Thank you.
Thank you.
Okay, let me get started. So, I want to thank you all. If I haven't spoken to, there's many of you here that I've probably never spoke to before or worked with. But I have a background of working inside title company offices and in various positions within the office. And so I don't know everything about title, but I know how to look at a preliminary title report and analyze, what's important and what you need to know, whether you are a listing agent, buyer's agent, or even a consumer or a lender. What is needed to clear certain items. And not everything is going to be on this presentation, because there's always, some files have some very odd situations that come up, and we can always talk about that after the meeting or after this class. I've done this class. I've been doing this class for, 4 or 5 years. There's always something kind of new to go over. Okay, so I'm gonna get started. And so just a quick note, if anybody has any questions, I'm happy to answer questions during the meeting. You don't have to wait till the end, because there may not be time for questions at the end. So feel free to drop questions into the chat bar as we're going along if something doesn't make sense to you. When you see your preliminary title report, depending on which company it comes from, it may just have a different layout, but typically all the same information is included here. And so, when you're looking at the first page, you may just skip right past it most of the time. But there are some things that you should maybe pay attention to and be ready to have. Right here, item number 1 is always, the prelim is usually addressed to the escrow company. It's sometimes addressed to the agent if they ordered a report earlier, but this is your escrow contact. So if you're the buyer, these are the people that you want to come to with any questions about your report, usually first, because they are in the middle between you and the title company. Usually you don't need to call the title company directly unless there's something that's really difficult to fix or to understand. But generally, the escrow is your first point of contact in the transaction. So you have your name of the escrow officer and then the property address right here. So when you're looking at the property address, make sure it's your property, because sometimes there's similar addresses that could come up. Oh man, my notifications. Sometimes there's similar addresses, so just double check the address. And then 3 and 4 over here, you have your escrow number, your escrow company's number, and you have the title company's reference number. And these are important if you're ever emailing escrow or title. If you want to get a quick response from your escrow or title, make sure you reference these numbers in your emails, because they will be able to jump on your question right away by bringing up your file. If they have to look through if they have to go by the buyer's name or the seller's name or the property address, it may take them a little longer to get to answering your email. So keep these numbers ready when you have questions in an email. Next thing you have here is a date. And you'll notice that there's actually 2 dates on the report. There's one right here and there's one down at the bottom. Only one of these dates is really important. The first one up at the top is more recent. This is when the report was issued. But down here you have dated as of February 14th. This is important because you are only going to see on this report what is of record up until February 14th. This is 2019 when it was created. So if something recorded the day after February 14th or a couple days later, it's not going to be on this report yet. So it's very important. This is another thing that I want to give you all a tip. Do not ever record any documents just before opening escrow or as you're opening escrow without talking to your escrow and title partners, because it could take a couple weeks for that to show up and be addressed on the title report. So you want to make sure you give those documents to the title company who's handling your transaction. And this, it doesn't matter what this is, if it's a refinance or a sale, you always want those original documents to go through the title company you're working with so that they can make them of record in your report right away. So like I said, anything after this date is not going to show right here. And then on this first page, you almost always have your title officer's name and signature right here, contact info. So if you ever have questions that need to go directly to the title officer, you should have contact info right there. That's always where to find it. I'm not going to go over this paragraph in the middle right here. It's basically just a disclaimer every title company has that they're, issuing this report. But here we have number 9 in this report is describing the type of policy you're getting. Okay, if you're selling a vacant land, you're only going to get a CLTA policy, basic title insurance. But if you're selling a home or even a commercial property, it may be an ALTA owner's policy that's being issued, and then a loan policy as well, if there's a lender involved. This may or may not be accurate when you're looking at the report the first time, because you need to actually tell us if you want a different type of policy. And you're typically not going to change the type of policy. You always want this ALTA policy when it's for residential property, because the difference is the ALTA is going to cover off-record matters, things that are unknown to the title company and to other parties. And you're paying a little bit more for that. We always consider the CLTA is called basic rate. And then when it gets to the ALTA, it's usually 110% of the price of the basic rate. So ALTA, very important. So I'm going to move on to the next page. And if you guys can't see, I can always zoom into some of these things during the meeting. So let me know if you have trouble seeing anything. The property here is a freehold estate. If you remember from your real estate classes, you could have either a freehold or a leasehold type of property. A leasehold is going to be very rare, but they do come up. There's maybe less than 10 probably properties that are, there's probably more, but there's very few properties that are leasehold. It could be a co-op, or it could be, it's usually a co-op if it's a leasehold type property. It could be also maybe a mobile home type of situation. And then you got the owner's name and how they're holding title. So we have here the property is in a trust and shows John and Jane Doe as their trusts. And this is important also. When you see a trust, make sure you spell out the full trust on your contracts, because there could be different trusts that the property could have been in, or these people may have multiple trust agreements created. So the complete name of the trust is important all the way through the date. The date is part of its identity. And then you see it says subject to paragraphs number 16 of Schedule B. So this is a sort of a red flag. It's not an alarming red flag, but it's a red flag for you if you are representing a seller, because this means that there are some uninsured transactions that have happened in the past since the last time it was insured. And whenever there's an uninsured deed, you have the title companies want to confirm those deeds that were uninsured with the parties that came off title. And the reason they ask that is because, first of all, we're making sure there's no fraud, that, you know, Uncle John's name didn't come off title, and he didn't know about it. Or another thing we're looking for is unrecorded agreements between these parties. So let's say Uncle John did quit claim his name off of title, but he also said that when you sell this property, I want $20,000. We don't know all this stuff, and this is stuff that could come back to get us. Because remember what I said previously, the ALTA policy is covering you for unknown matters. So if a lien pops up after we close from Uncle John saying, hey, I went to court and the judgment says you owe us 20,000. Well, that could be something enforceable, a lien that's enforceable later. So you see here you have subject to paragraph 16. We'll get into that when we get into Schedule B. It's going to list those uninsured transfers when you have later in Schedule B when they exist. So then you have the legal description of the property is also on this page. And here, keep note, we talked about the property address being correct. This is even more important. Some properties come with an attached vacant lot right next to it, a small vacant lot with a separate tax parcel. I've seen one property where half of the property was split and there were two separate parcels, and they actually had a prelim issued from it wasn't my company, it could have been my company, but a prelim was issued with only one of the parcels and not the other. And as it was listed for sale online, it was saying two parcels, and one side was this vacant piece of land. So make sure that all of the lots are included here. And keep note of this parcel number. I'm going to come back to it again when we're going to go over the assessor's map towards the end of the presentation. So getting on, we have Schedule B. So what is Schedule B? It's a list of items that are affecting the property. Everything on record that's affecting the property. It's not going to show things that we don't know about, but sometimes we may see the last title policy might say something like an unrecorded lease, or some things that are unrecorded, or an encroachment was known in the last time it was insured. So those things we might have picked up from the last time it was insured, and we may show them on a report, but generally these are everything reflecting on the public records. So the first thing you have is the property taxes. If you're representing the seller, again, make sure that they're not paying their property taxes outside of escrow. Make sure that they coordinate with escrow and title when they're paying any property taxes, because there could be some lapse in time where we do not see that they're paid, and we may need to either wait, or we may need to hold money, or we need to confirm that they were paid. So you don't want to do that. It's best to just pay taxes, liens, all that stuff through your transaction. If you're representing the buyer, pay close attention to these taxes, because if they look astronomical for the value of the property, this could be something that makes the property unaffordable to your buyer. They could have some special taxes included, like a Melrose or a bond, or even a hero or pace lien that's included in the taxes. Hero and pace is not in this report. Oh, here we go. Actually, payment of contractual assessments. So, in this report, you can see there's delinquent taxes due. That's not going to be on every. You have a local assessment that's included in the total taxes due. Everything about the taxes included in the total. But item number 6 here, you have a contractual agreement, and in California, we know those as typically hero or pace. These two types of tax items are loans on behalf of the state government, where they have paid for upgrades on the house to make it more energy efficient, like solar panels, like new windows, insulation, roofing. Any of that stuff you can borrow money from the government, but the thing is that they include it in the property tax bill, and that's to protect that investment because the property taxes have the highest priority when it comes to liens on a property. Property taxes are always number one, first position. So if you have anyone has questions about the taxes, drop a message right here. And thank you all, everybody, for the birthday wishes. Happy to spend my birthday teaching you guys. On the next page, so we have items 7 and 8 are easements. So if you don't know what an easement is, you may want to look further into it. But basically, it's a section of land that is designated for the use of another party, or usually a utility company. These easements could affect your buyers if they want to do additions. You might want to know where the easements are, that they may affect that guest house or ADU or added bedroom to the back of the house. You may want to know where the easements lie. So make a note. If you ever want to know where the easements are, ask your title company for plotted easements. And I'm going to put that in the chat. Plotted easements. This is going to be a colored map that shows where the easements sit on the property. I did miss one question from the taxes. Usually, how long does the tax delinquent become a lien? Well, anytime the taxes from the previous years are unpaid, they show as tax delinquency on the report and on the property tax, where the property taxes are shown due online. But when it becomes a lien that shows on the property, it doesn't really come up as a lien on the property, as a recorded lien, until it becomes what's called power to sell, tax defaulted property. They record that document, and that means that the property can be auctioned off at the next available auction date for that county. But when taxes are delinquent, there's nothing extra that shows up other than on the tax information sheet that the title company has. It shows previous years unpaid delinquent, and so we list that. And it's not something where we have to order a demand for the amounts due. We just check the week that we're closing. We check for the newest amount that needs to be paid, and we send usually if it's delinquent, a check is sent to make sure that it goes through. So I hope that answers your question. Back to easements. I mentioned plotted easements. That's how you can find where the easements sit on the property. Generally, if you see only these types of easements that you see here, like utility easements are almost always on the setbacks of the property, the rear 5 feet, the side 5 feet, etc. They're not usually like easements that will really get in the way of adding a bedroom or an ADU. They could get close to that depending on how much space you have in your backyard. But those aren't easements to worry about too much. But if your client's ever concerned, don't be afraid to ask for the plotted easements. The next item, number 9, is CCRs. And this could come in it could look differently on different properties. There could be different types of CCRs. There could also be just agreements. Often when you buy a new home or a condo, there are many of these recorded because they record the first CCRs for the project, and then they record amendments and amendments and amendments. And then there's one that's really common on brand new homes called a non-adversarial clause, something like that. There's some agreement that you should look out for, and every buyer of a new home is probably seeing this. And it's basically saying if you have any problems with the structure of the house or anything built, that you won't sue the builder, that you'll come to them first and that they'll fix it. So you'll see one of those recorded on here. And all these items should be hyperlinked when you have a prelim. So you should be able to kind of just look for that blue hyperlink on your reports. Pretty much every title company does that. And you can click and see a copy of it. And you can see right here, the government code document contains any restriction. If you see anything on a CCNR, you can't remove these from history because they may have other things in the CCNRs, and it would take every property owner plus some attorneys to completely remove a CCNR from an old property, from an old neighborhood. And that's just not going to happen. But basically, these run with the property until pretty much forever. CCNRs, these are really important to look at with condos and new homes. Make sure you read through the CCNRs. It's not hard. It may be 100 pages, 200 pages, but there's always an index where you can kind of see what might be important. So you can look at the index and you could say, I want to know how I can enjoy my common area or my area. I want to know if I can put a barbecue on the patio or things like that. You're going to find all the answers in the CCNRs, and just scan through that with your client if you're the agent. Make sure they understand it. No questions about that. Going on. Next item is a deed of trust. In California, this is what we call a mortgage. If you ever want to be super proper, it's called a deed of trust. Here, we actually, it's because it's a different type of contract where the lender is lending money. In other states, it's called the mortgage. So the deed of trust, that's if you're a really busy agent and you've been doing this for a while, make sure you know what a deed of trust is. So if anybody brings it up, you know what they're talking about. This is a very common document. So the deed of trust, the deeds of trust listed are the loans that are due. We don't have the amounts that are actually due to pay them off. A lot of people ask me how much is owed on the property. Really only estimate, and you could tell them like 516 from 2011. They may have paid it down a little bit since then. There's some ways to estimate, what might be owed, but it's a private information between the borrower and the lender, and so they'll give escrow they'll allow escrow to order that demand for the payoff at the end. Another thing about the deed of trust, a lot of people ask me for a copy of the note. The note, it's also called the promissory note. That is not something anybody has access to except for the lender, and the borrower may have a copy of it. But the original note is a private document that the lender holds, and they surrender the note once the deed of trust is paid in full. It's part of it's a very important document. If you're ever doing a private loan with somebody, make sure you keep a copy of that note, because it's really important when they pay you off that needs to be surrendered to a title company. Let's see, any record of this class. We're recording this class, so you'll be able to watch it again later. So again, to the deed of trust, if the property is in default, it will also show below the deed of trust. You can see right here, it says notice of defaults under terms. A notice of default is another class to get into, but basically, if your property is ever in default that you're selling, don't be afraid to list the property that's in default. It's not going to bite you back. It's very possible to sell a defaulted property as an equity sale if it has equity. The main thing is the agent is to be on top of the dates in that sale. You may want the homeowner to allow you to speak to the lender in case you need to check in. So the lender is going to be scheduling an auction, and you need to make sure that the auction date doesn't come close to your closing date. If the auction date is scheduled, you need to close 10 days before the auction date, or you need to make sure you get the auction date postponed. Otherwise, title and escrow will not close. They will not close the transaction, because what could happen is we could close one day and a couple of days later, the auction could still take place. And then you'll have someone buying the property, and then it's going to be a huge mess. So title and escrow will not close close to an auction date. So here, item 11 and 12, you have some more deeds of trust. So they pretty much go in order of the priority. They're listed on here, but unless you see what's called a subordination agreement, that's a document that allows one lender to swap positions with the other one. So if you had a first and second loan and you were going to refinance the first, that second lender needs to give a subordination agreement. They need to sign that. in order to switch positions again, since they're recorded later. Any questions about deeds of trust? Another thing about deeds of trust is if you ever see, this is like for a buyer or a seller, more importantly, a seller. If you ever see a really old deed of trust from like the 60s, 70s, 80s, and they're not cleared up here, get on that right away. If your title rep didn't bring it up, call them right away and have, everybody start looking into it. Talk to your seller, ask them for all the records that they have. If they have a paid in full letter, they may even have the unrecorded reconveyance for that loan sitting in their records. Records are really important with loans, even if they're paid off. I would advise you to advise your clients to keep records of everything with their loans, even when they're paid off, even if it's for a house that they just sold. Hold on to that stuff for a little while. It's one of the few types of documents that you should keep track of. The payoff, the paid in full letter, a copy of the deed of reconveyance. Keep all of that on hand for all the deeds of trust that you've paid off. That could, so what happens if you cannot pay off a deed of trust or find a record that a deed of trust is paid off and it's not a bank that you can order a demand and get it all cleared up? You need what's called a bond for lost note or beneficiary. If you cannot find the lender, what's called the beneficiary, or you cannot find that original note or any of those things, typically the title company will require a bond in order to clear it up. The bond acts as a sort of a release or a reconveyance for that missing document or the lender that's hard to find. So questions about that situation, you can always contact me outside of this class. Return on time. So I'm doing pretty good on time. So if anyone has any questions, please reach out. I got plenty of time to answer questions. Item 13, this is where we're starting to show some of the liens towards the end. These liens are usually the last items in Schedule B. You have a judgment for child support. You have a lien to the Franchise Tax Board. When you see all these things, make sure when your homeowner looks at this report that, that they need to be open-minded that these liens might not be their liens right off the bat. If they have a common name, or even if it's not a common name, there could be a name similar that comes up with these liens. Let them know that if they believe these liens are not theirs, that they just need, we always ask for what's called a statement of facts or statement of information. And this is how we clear up the liens. And we almost always show these liens that we find, anything we find that's remotely close. And, it could reference the property address, the owner's name. If they've had a lot of liens, we're going to see like the last four of their social attached to each of these liens, and we're going to be able to match it with the property usually. Something to know about judgments. When you see a judgment on a report, you may have a client who filed bankruptcy. So keep in mind that a bankruptcy does not automatically clear up a judgment. A judgment is a different type of lien from like a credit, like when you owe a credit card company or something. And when people file bankruptcy, they often don't consider that if they have a judgment against their name, that just like, let's say the judgment is on behalf of Capital One and they discharge debt from Capital One, but Capital One was not paid for several years. So they went ahead and filed a judgment against that person for whatever amount was due on their credit card. And then the person went and filed bankruptcy. Well, the bankruptcy attorney doesn't always suggest this. They may or may not. Maybe you're not paying attention when you're filing bankruptcy, but there's a second route that they have to take. They have to request what's called a motion to avoid lien for the judgment, a motion to avoid lien or creditor. And this is going to make the judgment, it's not going to void the judgment. The judgment will still last until it's out by time, but it stops the creditor from being able to enforce the judgment, going after them for the amounts due. So it also allows a title company to not pay the judgment. So if there's a motion or order to avoid lien, title companies will see it. We have access to court records and we will see that it's there, and we will see if it's not there. And if it's not there, your bankruptcy attorney has to reopen the case and ask for that motion to avoid lien. So, keep that in mind if you have any clients that have filed bankruptcy. Things like if they own a small business, or if they've, if they're kind of like business people, or they've had this maybe history, they've had some divorce or things like that. It's possible they may have had a bankruptcy, just because these kind of things are volatile situations. Sometimes when you've owned a small business, you may have people that you had to pay, and they got angry and they filed some judgment against you. All these things are possible red flags when you're looking at liens against the party. What if you can't pay a lien? You have these liens, state tax liens, federal tax liens. They have to be paid. Title companies are responsible for paying these liens. If you don't have enough in the proceeds to pay these off, you have to ask whoever the lien is on behalf of to issue a partial satisfaction of that lien. They can only pay 40,000 of 100,000, etc. And we need at least to pay whatever the if it's the IRS, whatever they deem it acceptable to close the transaction. Now we get to item 16, which is from the first page back where we had the trust subject to item 16. This one is not too alarming because it's just these parties are just putting, so we have the trust deeding to Cindy D relative, whatever they called her, Cindy D relative. So it's been deeded from the trust to this other individual's name. Anytime that happens, it depends on, who these people are and what their situation. If John and Jane are deceased, maybe Cindy was the beneficiary of their trust. Maybe she was the successor trustee and they transferred the property to her. If they're still alive, then they have to confirm that they transferred the property to her, and the trust still has to be reviewed, a copy of the trust agreement. So anytime you have this effect of a conveyance of land, uninsured, title company will ask for a confirmation of conveyance or a note or an affidavit of uninsured deed. And it's asking, are there any unknown agreements, unrecorded agreements, or anything due? And yes, did you in fact transfer the property to this other person with a notary? Let's see, you have 17 and 18, we're getting into solar agreements. So this is something to look out for. If you are the listing agent and you didn't know they had a solar agreement and you're already in escrow, make sure that you're asking these questions. If you see the house has solar panels, call your title company and ask, what's showing on the property. Know about this stuff ahead of time. Make sure that you, obviously, because you guys have to disclose it to the buyers, and they may have to accept the contract. The contract will be terminated and reassigned to the new buyer. So this is really important to look out for as agents. Another thing is the solar, if it's not paid off, this could also be a fee that you got to make sure your buyer is comfortable with. See, we have a question. Does Heloc show up as a lien? Do we as buyers or buyer's agents need to look into that, or it will be automatically cleared as other mortgages are through escrow? Okay, so, well, a Heloc, there's actually a Heloc on this report, and I'll show you how it looks on the report. This third deed of trust, we just call it a line of credit on the report. We know it's a line of credit because the recorded document will say that it's a line of credit. The deed of trust for 45,000, it's item 12 here. We need evidence that the account has to be frozen and paid off as well. But that's a good question because a Heloc is sometimes not recorded. Lenders they're very sloppy and lazy with low loan amounts. They sometimes don't record them. Most of these Helocs are recorded without title insurance. They're often submitted through a title company, like a major title company, to record them. but they're not reviewed for to give title insurance. They just kind of record them, and they are sometimes not recorded. So if it doesn't show up, usually we have a form that the seller fills out. It's not always from every title company, but if there are no liens showing on the property, we may ask them to sign and confirm that they do not know of any other liens affecting the property. Of course, something like a Heloc could potentially come up after the transaction's closed, and then it could be a lien against the property if it's not paid. It depends on the lender if they notice that a property was sold. I highly doubt that any lender who didn't even record a Heloc would notice that they weren't paid off when a property was closed, but it is possible that it could be unrecorded. So let's see, we have gone over all these items. Solar panel liens need to be subordinated. Yeah, Judy asked, does a solar panel lien need to be subordinated? It only needs to be, well, yes, if there is a solar contract, and it's gonna, if there's a new loan coming onto the property, yeah, the lender has the requirement, any first position lender for a purchase or refinance, they will never take second position to a solar panel. So yes, the escrow usually orders subordination. It depends on how the contract is set up. Sometimes they just terminate it and then they reinstate it after the transaction closes. That's kind of the most common for like a refinance. Let's see, a few years ago, I attended a class that we can purchase other owners' second TD to qualify my own 1031 exchange transaction. Is this still legal now? Oh, okay, so rather than, Frankie, I think you're asking, rather than purchase a property, the exchanged property is actually the second deed of trust on a property. I don't know everything about 1031 exchange. You should reach out to a 1031 exchange expert because they are following. There's so much going on in that world, in legalities, the 1031 exchange, that they're changing it every year because it's kind of political. But if you don't know a 1031 exchange expert, I have a few in my contacts that I can send you afterwards. I'll send you an email, Frankie. Ho. Pretty sure I got your email somewhere. Let's see. You're welcome. Let's see. Okay, so then item 19 here is about a trust. So if a property is held in a trust and you're selling it, we may be asking for a copy of that trust. If the original trustors are selling it, there's not really much to see. But typically, if a lot of times when we come up with a trust sale, it's often that maybe one of the parties is deceased. There's a successor trustee. We always have to make sure that there isn't something in the agreement that says, that someone has rights to the property based on the trust. Before it's sold, they need to agree to the sale, or they need to be given the option to purchase the property. There's so much that can be stated in a trust. So if you have a trust and a sale transaction, make sure you're ready to provide a copy of the trust to the title company. Our title search has disclosed possible liens and judgments that cannot be eliminated. Okay, so we went over this, and you need to make sure that statement of information is submitted right away to escrow and title. Generally, you send it to escrow and they forward it to us. But if you're the agent on this transaction and you think your client might have some liens that didn't show up, it's good to be proactive and call the title company or the escrow and make sure they run that name early on, because what happens with the statement of information is we will check it the first time escrow sends it to us, and then if the transaction sits for several months and some other lien comes up, it won't be brought up again until escrow says, you know, please, we're setting this up, transaction up to close. Can you please clear the statement of information again before we close? And that's when, you know, maybe some other lien pops up that was, you know, wasn't recorded yet, or, you know, so basically escrow needs to tell us to review the statement of information for their file, because we're not just running names all day long for transactions that we don't know. If we don't know a transaction is moving, we have tons of transactions that sometimes sit for a year. Sometimes they're canceled and we don't even know they're canceled. So, you know, it's best to be proactive and give your title company instructions to clear the name on the property. No other questions coming up here. The very last item, well, okay, before we get beyond this, make sure you read through the next few pages of your report. I don't have it in my presentation here, but there's always a section called notes and requirements. And obviously you want to look at this because they're requirements listed on there. It's going to say what type of documents we need from the seller, you know, and you know what we need to close this transaction. It's going to elaborate on some of these items, because right here it may not say what we need, but it's going to elaborate. We need, you know, if something is happening, we need this item for it. So looking through the notes and requirements section of your report. And then after that, you have your plot map. And I'm gonna, so here you have a plot map. How do you read the plot map? You got to get your parcel number. So I'm gonna scroll back up, and I know it's sideways, but let's see. That plot map, or I'm sorry, that assessor's parcel number is back on that page where the legal description was, and I rotated it too soon. So we have a parcel number right here. Even for other counties, it's pretty much the same. In all Southern California, there's the first three sections are what's called your book, page, and the parcel number. The 5658 is our book, page 8, and the page is the plot map that we're going to look at. We're going to look at page 8 of the plot map. If it's in San Bernardino County, there's going to be multiple pages on one map usually, and also for Riverside and some other counties. But for LA County, we have one page for one map. So we're going to go to page 8 and looking for parcel number 7. And, you know, the person that created this, they labeled the parcel 7, but also the lot is 7. So the circled number is related to your parcel, your APN, and the number that's not circled, this is your legal lot. That's with, and here's the tract number. So the tract number was 8163 and lot 7. But the circled number is how you're going to find your property. And if you see some dotted lines, it means a lot was split at some point or separated. If you see all dotted lines on your map, that's possibly a red flag. That means that the lots were created without compliance to the, it's like called the Subdivision Map Act, and you're not going to see that too often. But if you see a map and all the lines are dotted lines, that could be an issue for a lender, and it could be even an issue for a title company to issue insurance on it, just because it's not a proper legal description. And those do come up, a lot of them in the hills, in parts of you know, areas where there's not a lot of homes and it's not really well organized. Let's see, so we got some questions here. Let me go back to Pauline, or you just sent me. And seller can request this. Can seller request to switch to another title company while in escrow? Okay, well, yeah, okay, so Andy asked, can a seller request to switch to another title company while in escrow? The seller can, I mean, of course, there's got to be a good reason to switch title companies once you're in escrow because, um, you know, title company is already, they've already spent money to create their report. They've put time into it. If the title company can't close the transaction in the way everybody's asking, then the buyer and seller can agree to switch the title company. It's if you don't need to switch title companies during escrow, you don't need to do it. If you're just really unhappy and you really want to do it, go ahead. I mean, I have people calling me sometimes and saying, I'm having some issue with a file at another title company, and I prefer even to just talk them through it and hope that they can just close it out with whoever they have the file with, because it's going to slow things down. You got to wait for the title company to make a new report, and they may come up with same issue. Once they create the report, they may also have the same requirements and the same issue going on. So if you're just generally really unhappy with the title company, you can always do that. But if it's just a matter of clearing a hard item on a report, and that company is not willing to do it, and that you've tried everything, go ahead and make the switch if you have to. From Stephen Montoya, see, I had a title report that indicated in Schedule B the lack of legal right of access to and from a public street or highway. Is that a definitive assessment that there is no legal means of access? So yes, I mean it's not the end-all answer to so the question is, like, the report is saying that there's no access from a street, which is required when there's a home. If you have a vacant lot with no street access, it's not out of compliance, it's totally fine. But if you build a house on it, then you need access to the street. Now, if you know in some other way that there is access, make your case. I had a transaction where everybody kept swearing up and down that there is access to the lot. They just have to drive through this and this land and this land. And, well, you can't do that because there needs to be expressed, like, written consent from all of those owners that they're going to allow access through their lot. Even if you've been driving over it for, many years, a title company is going to want to make sure that all of those people are okay with that access route, and it should be described somehow in an easement. An easement should be drawn up for access through those other lots if a public road is not adjacent to the lot. I hope that answers that question. Yes, Alexandria Wong, can I get a copy of the PowerPoint? I would love to send anybody a copy of this PowerPoint. I put my email in there. If you can send me an email, I'd love to connect with you, and I can send you a copy of the PowerPoint. And I can also sign you up for, access to property profiles and documents and things like that. I have a couple of apps for that. If a transaction is already closed, second lien which was not recorded or found on the prelim title report prior to closing, who does the lender of the second lien go after? The previous owner or the current owner? That is, they can start by going after the previous owner. If the original borrower doesn't intend to pay it because they've already sold the property, ultimately they will file a lien against the actual property, and it will become a title claim. Because we've already closed the transaction, we've issued insurance, and now it's the responsibility of the title company to cover what we didn't find and clear up. I mean, it could go different ways. The title company could end up, opening litigation against the previous owner for not disclosing, depending on what kind of documents they signed. Maybe they signed something saying they know there are no other liens, and that may be a way to get the previous owner to pay that second lien. So yeah, it's a possible lien. it's a possible claim against the title company if the seller didn't want to pay it. From Letty, let's see, I have a question related to title, not necessarily the report. Not sure if this question is related to the presentation, but perhaps if you can call me after. Oh, okay. Yeah. So could you explain how whole transaction? Okay, so yeah, I mean, you guys can all call me later. And I gave you my email. Here's my phone number again. We're probably, I think we're about out of time. If there's any more questions, you guys have my phone number and my email address. So feel free to reach out after the class. And I hope I covered everything. Can I get it? So yeah, everybody just reach out to me later if you need anything, if you want a copy of the report, and I'll pass it back to Sylvia.
Yes. Thank you so much. It was great presentation. I really enjoyed every bit of it.
Thank you.
If anyone else has more questions, again, he said you can email him that question, and I'm sure he will respond. He's very, very quick at responding, to our inquiries. Thank you, Joe, very much. I hope every one of you enjoyed it. And as you know, it's been recorded, so we're going to get a copy of that, all of us, okay, to review. Thank you so much, Joe, and happy birthday.
Thank you. Yeah, I'm really old now.
Great. So any question?
It looks like we're done with questions.
Everyone just want to say happy birthday to you. Okay, great. Thank you, Joe and Sylvia. What a great section. So thank you for your time, especially for your birthday time, and we appreciate. Okay, we're looking forward to meeting you, everyone, together in person very soon. On behalf of Western Gabriel Valley Realtors, we would like to thank Joe Haggerty, Orange Coast Title, for your wonderful and valuable presentation to us today. A reminder for our next class, Monday, November 23rd, Zip Phone Plus. It will conduct by Ling Chao from 9:30 to 12:30. Thank you so much. What a wonderful spending time with all of you. We want to say thank you, Joe, Sylvia, Jeff Huang, and especially thankful Fang for conduct the meeting every time for us so smoothly. We see you next time, and happy holidays and early happy holidays if we don't see you in education committee meeting, but please do tune in next Monday for our Zip Phone Plus class. Thank you.